who had the original care and control. This underscores the importance of the co-parenting and access of children in the best welfare of children after the divorce. Relocation cases are often one of the most difficult cases to decide. And Justice Prakash decided in BNT and BNS that the paramount welfare of the children always lies in these cases, and it also involves different circumstances to be looked at, including the loss of bond and relationship to the parents to be left behind. Another landmark case that we are all familiar with is this case of UDA and UDB. The court was faced with the issue of whether third-party claims could be made in divorce action in a divorce action between a couple, and the court's approaches in such cases. Justice Prakash distilled the principles to be applied in such cases with clarity of thought. Justice Prakash also clarified in TNL and TNK that while the approach in ANJ and ANK applies to double-income families, the approach is not applicable to single-income families when it considers Section 112 of the Women's Charter. Justice Prakash was also in the quorum that decided the surrogacy case of UKM and AG, decided in 2019, in which a gay man wanted to adopt his natural child. The Court of Appeal in that case analyzed the interplay between surrogacy, public policy, and the legal context of a case in Singapore. The principles that is enunciated are truly very illuminating. Indeed, a quick browse of all these cases in LawNet shows that Justice Prakash heard not less than 50 reported family cases to date. Justice Prakash undoubtedly is a person who has vast experience over the different areas of law and wisdom to share with us today. It is now our privilege to invite Justice Prakash to deliver the CJCO Family Law Lecture for this year, 2021. Justice Prakash, please.
Minister for Culture, Community and Youth, and Second Minister for Law, Mr. Edwin Tong, President of the Law Society, Mr. Gregory Vijendran, members of the Organizing Committee, family lawyers, ladies and gentlemen, good morning. It is indeed a great honor for me to have been asked by the organizers to deliver the CJCO lecture today. I understand that I owe this privilege to my rather long-winded and frequent expositions of my views on various aspects of family law over the many years I have been on the bench. Having been exposed to so much of my pontificating, it is very kind of family lawyers to give me this additional opportunity to share some thoughts with you. As we all know, 2021 marks the 60th anniversary of the passing of the Women's Charter. Over the past 60 years, the Charter has been the bedrock of family law in Singapore. It has set the norms that we apply to family relationships and to the treatment of the members of the family within our society. It has also been the premier statutory affirmation of the independent standing of the married woman in Singapore. Since 1960, the Charter has often been amended to increase the ability of the justice system to deal with the challenges that face the modern family. The courts and lawyers use the Charter as their Bible, albeit one that is not only much annotated, but has also been the subject of reams of interpretation and explication. Regretfully, there is no time today for me to explore how the Charter has driven the development of family law over the past 6 decades. Instead, I propose to say a few words on how the principles of Singapore family law apply to a subset of cases, those concerning the international family. I suggest that the collected wisdom enshrined in the existing legal principles must be applied to the international family as much as it does to the local one. The core of a family remains the same, whatever the nationality or global connections of its members. And however one wishes to define family, whether as the traditional collection of people joined by the law, or by birth from the same contributors to the gene pool, or as extended by adoption and technological developments such as surrogacy, familial aspirations remain largely unchanged. To the extent that the law reflects that, my suggestion is that our law has taken the correct approach by, in most respects, treating an international family no differently from any other family living in Singapore. I must quickly add, however, that as society evolved in its recognition of some of the special challenges that can be presented by such unions, important provisions have been added to the Charter to help deal with these challenges. For example, there is Section 11A, which expressly nullifies marriages between a Singaporean and a foreigner, which have been undertaken for the sole purpose of giving the foreigner an immigration advantage. More important, to me at least, was the introduction in 2011 of Chapter 4A of the Charter, which allows parties connected to Singapore who have gone through divorce proceedings abroad to apply to our courts for orders granting them the same type of financial reliefs that they could have received had the divorce taken place here. First, what is an international family? In our context, an international family can be simply understood as one where at least one of the spouses is not Singaporean. Although a 2019 study of divorces in Singapore concluded that such marriages tended to be more vulnerable since the spouses experience friction arising from different cultural norms, I am hesitant to draw any broad conclusions about the stability of an international family. Such generalizations risk missing nuance or being potentially pitched at too high a level of abstraction to be heuristically helpful. What I do see, however, is that there are certain profiles of international families, and these provide useful illustrations of some of the complications faced by international families when they break down. One example is the trailing spouse. This involves one spouse following the other to wherever his or her job may take him or her. Much of the couple's wealth is typically generated by one spouse, and the marriage is typically characterized by high geographical mobility, with assets possibly spread out across multiple jurisdictions where the couple has lived. Unsurprisingly, these couples tend not to have firm roots or familial support networks in Singapore. Another example is migrant bride marriages. These involve Singaporean men who struggle to find local partners and instead seek wives from neighboring countries. Such marriages are typically characterized by wives from less developed countries and older husbands with lower incomes. To put it in numbers, 49.5% of the Singaporean men married to foreign wives were more than 5 years older than their wives. Language barriers, uncertain immigration status, and the lack of familial support in Singapore contribute to the common anxieties that may feature in such marriages. I list these examples not to pigeonhole or to be reductive. These illustrations give a picture of certain marital situations that do not enjoy what some of us would take for granted in a marriage. Most marriages in Singapore, for example, are untroubled by immigration status concerns. These marriages may also experience old problems in new ways. For example, power differentials within a marriage may not be novel. But power disparities in a migrant bride marriage, magnified by the unfamiliar environment and the bride's heavy reliance on the husband for most or all aspects of life in Singapore, may well be a different thing altogether. As recent newspaper reports have indicated, when these marriages break down, the foreign wife often has no idea how to obtain protection or relief. In my view, it would be unrealistic to ignore the special concerns that can arise in an international family. Even as I consider that the existing legal principles are equally applicable to international families and equally equitable in their outcomes, we must acknowledge that in some categories of these cases, additional help may have to be provided to the parties. I would offer 3 ways of categorizing the legal concerns which arise with an international family. First, the complications experienced exclusively by an international family. Second, the complications which are experienced by all, but are perhaps more pronounced when an international dimension is introduced. And third, those legal issues that are entirely agnostic to the international or local character of the family. In the first category, I would include issues such as challenges to the court's jurisdiction and the invocation of our laws concerning immigration advantage marriages. Jurisdiction is rarely an issue when the parties are both Singaporean and have conducted their entire marriage in Singapore. And immigration advantage marriages, marriages of convenience, for the purpose of assisting a spouse to obtain an immigration advantage, are hardly concerns for marriages between Singaporeans. When problems with jurisdiction or immigration advantage marriages do arise, however, they tend to have ready solutions in the law. Questions of jurisdiction are resolved by time-honored tests like the parties' domicile and their periods of habitual residence, while the immigration advantage marriages are now addressed by specific provisions within the Immigration Act and the Charter. As for the second category, I have in mind certain ancillary matters which are sometimes complicated when international families are involved. These include care and control of children, division of matrimonial assets, and the enforcement of maintenance obligations. Such orders are both easier and harder to make. Easier because sometimes the international dimension cuts all Gordian knots. For example, when parents are living in separate countries with separate lives, shared care and control is obviously out of the question. The child cannot be expected to shuttle between continents to spend time with both parents. Sole care and control is the only realistic option. But knowing that the result of the order will be to largely remove the ability of one parent to have frequent physical access to the child makes the decision so much harder. That was precisely the court's experience in TSF and TSE, a 2018 case, where the husband, a Singaporean, lived here with the child, while the wife, a citizen of another Asian country, lived in the United Kingdom. There was no possibility of shared care and control, and there were very limited opportunities for physical access to the child by the parent who was not awarded care. The court therefore had to undertake a very detailed consideration of where the child's best interests lay, knowing that whatever orders were made could not be easily varied, especially if the child were to be sent abroad to live outside of the court's jurisdiction. Here, what the court did in coming to its decision was to apply the well-established principle of the child's welfare being paramount, but only after conducting an extremely granular consideration of the facts. It had to take into account matters like the child's liability for national service and his likely immigration status in foreign jurisdictions, which would simply not play a part in the normal run of care and control cases. Even where children are not involved, orders consequent upon divorce are often more difficult to make when an international family is involved. Deciding on division of assets can be challenging. With well-heeled, geographically mobile couples, there can be multiple assets spanning multiple asset classes spread across multiple jurisdictions. Identifying and valuing them for division can prove to be an exercise in speculation, especially when parties are uncooperative and not forthcoming about their assets. Such difficulties are illustrated by the case of TOF and TOE decided this year by the Court of Appeal. The assets in that case ranged from shares in listed companies to shares in Cayman Island entities, from cash in bank accounts to cash in holding companies, and from foreign real property investments to the couple's matrimonial home. These assets were in turn variously located in Hong Kong, the United Kingdom, Phuket, Bali, and of course Singapore. The total asset value initially claimed was in the range of $40 million. The point here is not to harp on the size or complexity of this international family's asset division exercise. I am confident that some divorces between Singaporean spouses tell the same tale. The point is that certain types of international families may involve a specific cocktail of socioeconomic status, cultural friction, and ruthlessness that particularly exacerbate legal concerns, which are otherwise universal to divorces. But when such cases come before our courts, there has, so far, been no difference in the procedure or the principles applied to the task of division. It is just that the court's job is made factually more complex and to a degree more speculative, because it is more difficult to trace and value assets located abroad. The court may have to rely on inference more than on hard figures to carry out its task. And in such cases, the goal of achieving equity between the parties is harder to reach. Quite apart from the fact that there can be no legal basis to disapply Section 112 of the Charter governing division of assets just because the divorcing family is an international one, I believe that the principles the courts have developed over the years in their implementation of Section 112 have created a just framework within which to recognize and balance the contributions of the separating spouses to their international marriage. I also spoke of a third category of legal issues earlier, those which simply do not discriminate between international or Singaporean families, and which would, in my view, be experienced equally by all divorcing couples. One need not look further than the sole ground of divorce accepted in Singapore, the irretrievable breakdown of a marriage. And under that, facts such as desertion or separation are legally identified by clear temporal requirements. These bright line rules are obviously applicable to all who seek divorces here. Organizing these complications in this manner offers at least one point, The differences between an international family and a purely Singaporean one do not demand any extraordinary legal measures beyond the capability of existing frameworks. Should certain issues arise exclusively in the context of an international family, the law's response is to find solutions in existing principles or practices, to the extent that these issues are not covered by international conventions to which Singapore is a party, such as the Hague Convention on the Civil Aspects of International Child Abduction. An example of this can be found in the case of BDU and BDT, decided in 2014, which concerned a young child born in Germany to a German father and a Singaporean mother. To simplify the facts considerably, the mother brought the child back to Singapore without the father's consent and then refused to return him to Germany. The father started proceedings for the child's return under the International Child Abduction Act, which had been passed to implement the Hague Convention as part of Singapore law. The mother resisted the proceedings on the basis that the child would be at grave risk of psychological harm if he was separated from her, and if she could not return to Germany with him due to medical, specifically psychological reasons. When the case went to the Court of Appeal, the court of its own motion appointed an independent psychiatrist to assess the risk of physical and psychological harm to the mother if she went back to Germany. It should be noted that neither the Hague Convention nor the Abduction Act required such appointment. It was undertaken by the court in the exercise of its general powers under the rules of court to obtain independent and expert assistance in suitable cases. So a domestic procedure was applied to an international case. Subsequently, in analyzing the facts of the case and coming to its decision, the court applied well-known principles. For example, that of refusing a person to take advantage of her own wrong, to the case of an abducting parent. It also applied the commonly used technique of analyzing foreign jurisprudence to help it in the task of understanding and applying the Hague Convention. Although this was the first case under the Hague Convention to reach the courts of Singapore, it was dealt with very capably by using techniques and principles that are regularly employed in domestic cases. Thus, even where legal issues are particularly complicated by the international dimension, the analysis does not appear to change. The international angle is just one more fact to consider in an area of law that is already highly sensitive to the facts. It may offer practical problems, such as difficulties with enforcement in applications such as maintenance orders, or some uncertainty in matters such as identification of matrimonial assets. But these do not fundamentally change the court's approach. The grant of maintenance is still guided by the factors listed in Section 69, subsection 4 of the Charter. The division of matrimonial assets must be just and equitable as mandated by Section 112 of the Charter, and any orders relating to children must necessarily have their welfare as the paramount consideration, Section 125 of the Charter. One explanation is that family law is by its nature flexible enough to accommodate the increasingly international character of families today. That flexibility may be born of family law's naturally fact-sensitive nature, and may mean that even its foundational tenets possess a certain degree of limberness. In that regard, the increasingly common phenomenon of international families does little to seriously challenge the principles of family law. This is best illustrated with the law's approach to child relocation applications, which arise out of both international and local marriages, since Singaporeans are notoriously peripatetic. As explained in BNS and BNT in 2015, the law's first and foremost concern is the child's welfare. In the child relocation context, that principle is informed by factors such as the wishes of the child, the proposed access plans for the non-custodial parent that would address the potential for loss of the child's relationship with that parent, the potential destabilizing effect of uprooting the child from existing arrangements in Singapore, and the existence of support networks in the proposed destination country. These factors do not change when applied to international families. In fact, they are worded broadly and are not part of an exhaustive list. The controlling principle remains the same, and for that reason, it appears that the Court of Appeal in BNS and BNT did not find it necessary to go any further to fashion special consideration of special factors for the Canadian parents that had come before it in an application where the Canadian mother wanted to take the Canadian children back to Canada, but the Canadian father wanted them to remain in Singapore where he was employed. Another explanation is that our family law principles are themselves fairly universal in nature. Zealous advocacy for the best interests of the child, an emphasis on parental responsibilities over parental rights, and the belief that family disputes should, as far as possible, be resolved outside of a courtroom. These are the sort of principles which are recognized almost universally. The best example of an international embodiment of one of our existing family law principles is the Hague Convention mentioned earlier. Though it is fundamentally an agreement among countries on jurisdiction selection in matters relating to care, control, and custody, the Hague Convention also accepts that universal aspirations must go beyond simply returning a child to his or her country of habitual residence at all costs. That is why it recognizes a limited exception when the child's welfare is potentially at stake. Grave risk that his or her return would expose the child to physical or psychological harm or otherwise place the child in an intolerable situation, as it is stated in Article 13b of the Hague Convention. The child's welfare, in other words, is a universally recognized principle that may, in certain circumstances, supersede international comity. And even when this exception is not invoked, there is a strong case to be made that the Hague Convention's concerns with jurisdiction selection are, by themselves, a commitment to the child's welfare. As Dr. Vivian Balakrishnan explained in the second reading of the International Child Abduction Bill, and I quote, that no court other than the child's habitual residence should decide on the child's custody should not be regarded as reneging from pursuing the welfare of the child. It is simply the realization that the welfare of the child is best served when the court so desists and leaves the matter in the hands of the court of proper jurisdiction." Unquote. I would go further. How these principles are achieved has also increasingly been the subject of some global convergence. For one, at least in determining what the best interests of the child may be, there seems to be a growing consensus that the child's wishes have a greater role to play. The thinking these days is that children desire to be informed about their parents' separation and to be consulted about future care arrangements. Children, in other words, desire a voice. This is crucial because children gain from participating in decisions that affect their lives rather than simply being the object of concern. Such thinking is pervasive, not just in Singapore, but in other common law jurisdictions such as Canada and Australia as well. Another growing global consensus centers on the role of social science professionals. This follows naturally from the recognition that a child is not a chattel to be bargained for at the divorce, but a person with unique and complex needs. More is required to understand people as opposed to property. And the quest for true protection of the child, therefore, is necessarily multidisciplinary. Like the Arthurian legend, all seated at the round table have a crucial role to play, joined not by the enforcement powers of a judge, but by the common purpose of uncovering an elusive holy grail, the best interests of the child. All these points go towards explaining why family law principles need not be modified to accommodate the international family. The existing ones may be flexible enough or already universal in applicability. It seems to me that family, at its simplest, is kin. This word has for years broadly conveyed the general notion of a group of connected people linked together by blood, law, and societal notions of the responsibilities they have to each other. My suggestion in this lecture has been that the international family experiences some unique problems, but is and must ultimately be treated by the law in the same way as any other family would be treated. Dwelling on the differences offers few meaningful grounds for differentiated treatment. What the courts and law of Singapore consider a good outcome in the sad and difficult cases of family breakdown that come before them would be similar, regardless of the character of the family concerned. And therefore, the same principles have to be applied to all. Thank you.
Thank you, Yona, for this sharing with us on your thoughts about international family. Yona, we would like to ask you a few questions, if you don't mind.
Yes, of course. I don't mind.
Yes, Yona, it's interesting that you started as a shipping lawyer. You hear so many commercial cases, arbitration cases, and finally you heard so many family cases. Can you tell us, Yona, what is the difference you feel between hearing a commercial case and a family case?
Well, a commercial case, by and large, is an intellectual exercise. Your decision generally has only economic consequences, and, well, of course, economic consequences for individuals sometimes, but more often economic consequences for companies. And therefore it doesn't involve very much emotion. You hear the case, you try and get the correct view of the facts, and then you apply the principles. When it comes to a family case, there is a great deal more emotion involved, because all of us are members of family in one way or another, as children, parents, siblings, and we are all aware of the problems that can arise in families and of the terrible consequences that can result when families fight. And the other difficult, so there is then that dimensional, I would say, sympathy. There was, some idea of sympathy or empathy that you have with the family, which you would not have in a commercial case. And then when it comes to a case of a family breakdown and helping the family reorganize their lives subsequent to that breakdown, there is such a lot of uncertainty. And you cannot, no matter how good your intentions are, you cannot be sure that you are doing the best thing for the family. You put forward a solution, you listen to the parties, and yet you know that you do not know everything about the family. You know what the parties have chosen to show you, what perhaps they think at the time is important, but there are lots of little details which may be significant, which are never brought to your attention. So in a way, you are making a decision which is will have an uncertain effect. So I do worry. I used to worry a lot when I made these family decisions, whether the outcome would be good or it would not be good. I remember there was a case when there was the custody of a child was involved, and this child had been living with her father for many years, and her mother wanted more access and wanted care and control. But by then the child was about 12 or 13, and the child came along and said, "No, I prefer to live with my father, because my mother is too strict." And eventually I gave the care and control to the father. Several years later, I learned that his control had been so lax that the child had gone through very difficult periods and had got into trouble quite a lot. So I felt bad about that. Maybe I should have given her to the strict mother instead.
Yona, this thing about the voice of the children, your personal preference in family cases, do you think that it is a good thing for family judges to hear children's voices?
Yes, I do. When I was hearing cases at first instance, which involved custodial disputes, I very often asked to see the children. I realized it was of limited utility, in the sense that you see a child for half an hour and you may get some valuable insights, but on the other hand, quite often the parents coach the child and you may not, and therefore the impression you will be given may be rather skewed. So I think that the move that we have now to have a child representative who can really look into the interests of the child, and perhaps a counselor who can interact with the child on several occasions for a longer period, that's a really good move, because then the voice of the child can be clearly heard by the judge instead of filtered through parents. And often parents put forward drawings or cards or letters that their children have written to the court. And while these are interesting and you must look at it, you can never quite run away from the suspicion that the child has been influenced in some way to write what he has or she has. And, children wish to please their parents. So if a parent asks the child to do something, they will do it. And on the other hand, there are some children who don't dare or who are scared of angering their parents. So again, their views they may not feel free to express their deepest views. So I think more time spent with the child by an independent party is really very helpful.
What would you think is disheartening or heartening about family practice so far in your experience?
Well, it is heartening, I think, now that you can talk with the parties and try and I mean, there's so much more focus now on mediation, on trying to get parties to work out for themselves the arrangements which would suit them and help them to go forward. That is very heartening. And in family practice, I think what must be heartening to all family lawyers is the fact that they are laying for or dealing with their clients' deepest concerns. And quite often, I think they manage to deal with them successfully and achieve an outcome which they know will be of benefit to the family. There are some cases, of course, where parties cannot work together, and sometimes the benefit to the family may be to have cut and dried orders, and that too you can help in achieving. But I think it takes a special type of person actually to work well in the family setting, because while you have to be endlessly patient, you also have to remain somewhat detached and objective in order to be able to advise your client on the best way forward. Because clients sometimes think, and I used to see this in affidavits, that the more they pour out their woes and the more vitriolic they are, the more they will be able to persuade the judge. But the judge gets put off by people who are so vitriolic, because the judge can then see that that person is a rather unreasonable person. And so less credence may be given to a person like that than to someone who is more measured and more selective in the complaints. So it takes a good a good lawyer with good people skills to move their obviously distressed clients in the right direction.
That's a good tip for the family bar lawyers in the drafting of affidavits in future. And I suppose, Your Honor, that is really important, because right now most cases are heard not by cross-examination but by the affidavit. So thank you very much, Your Honor, for sharing that with us. Your Honor, lastly, I just wanted to ask you the final question. Do you have any tips that you would like to share with family lawyers on presentation of family cases in court of appeal or in the court?
Well, I think the most important thing is to be fully prepared and to have gone through the documents. Nowadays, I mean, when I first started out, there was no such thing as discovery in family cases. And so we had nice short affidavits. But as people have become more affluent, and as the principles that we apply have become a bit more precise in terms of estimation of contribution and of assets, obviously much more documentation is required. And therefore there's discovery. And therefore we are presented with huge piles of affidavits or huge records of appeal. And yet sometimes when you ask a lawyer a question about a particular statement he has made, he or she is unable to find the documentary substantiation of that. So I think for the Court of Appeal, especially where time is limited, you really need to know your documents very well and to refer to them well in your cases and have them easily available in the core bundle. And perhaps you have to see beyond your arguments to the other side's arguments to know what the court is going to ask you. Because the court's not only going to ask you about what you've put forward, the court is going to ask you about what the other side has put forward. And therefore you must have the documents ready which would counteract the argument of the other side. And the other thing, of course, is to be fairly open with the court where you don't have it, or where things are not quite don't quite show the picture that you want, because there are two sides are put forward, and when one side seems to be prevaricating a bit, it doesn't give a very good impression. But knowledge of the file is really the most important thing.
Thank you very much, Your Honour, for sharing with us today. With that, I think we will be in for a second break. I'll be asking Darren to come in. Thank you, Your Honour, for sharing with us.
Thank you. Thank you very much for inviting me again. Bye-bye.
Thank you, Justice Judith Prakash. Thank you, Laylan, for that wonderful session. And now, ladies and gentlemen, we will now be having a break, and the next session will start at 11:30 a.m.